Hi, my name is Joe Bartolomeo. I'm an Oregon workers' compensation lawyer. I represent injured workers, and my offices are in Astoria, Oregon, and Hillsboro, Oregon. And in today's video, I'm going to talk about the workers' compensation fee agreement. I'm surprised I haven't made a video like this before. I may have and forgotten about it, but the ideas that I get for videos come from conversations that I have with clients throughout the week. And then maybe toward the end of the week or on a weekend, I'll come in and shoot a video, and my video helper person, who's great, will format the video and we put it up on YouTube. So this is a hopefully not too long video that talks about Oregon workers' compensation fee agreements. Now, there are a couple of things that you should keep in mind with the Oregon workers' compensation fee agreement. Oregon workers' compensation is a statute. That's all it is. And really what it is a statute that imposes a responsibility onto most Oregon employers to provide workers' compensation coverage for their workers if they're injured on the job. And the statute is really kind of like an insurance policy. And then it'll say, and if the injured worker, if somebody's injured on the job, one of your workers, here are the benefits that you have to provide them. And if there's a dispute about it, then the state of Oregon gets involved. So that's what workers' compensation is. And it really regulates every aspect of that, including attorneys and how they get paid. So the first thing I'll tell you about the Oregon workers' compensation fee agreement is that all it really is a compilation of the rules that talk about how attorneys get paid, boiled down into a couple of pages. And the thing to keep in mind if you're looking for a workers' compensation lawyer is that all the lawyers are going to essentially have the same fee agreement. They may write it up a little differently, but we cannot do whatever we want with fee agreements. This is not something that we have that option on. And so when you sign a fee agreement with a lawyer and you're an injured worker in Oregon, the fee agreement's the same no matter who you have as your lawyer. So let's get into the terms of the fee agreement and how that works. So when I meet with a potential client the first time, I explain to them that in the Oregon workers' comp system and in the fee agreement, there are two things that are true no matter what. Number one, the attorney only gets paid a fee if they are instrumental in getting you something that you did not have. And that means that I, as your attorney, need to do something positive for you. I need to get something for you that you did not have. And I have to be instrumental in doing that. It's not just something good happens while I happen to be representing you, I get paid. So this usually arises from a dispute. And the fee agreement covers all of the possible ways that we can get paid, but the lawyer has to do something for you positive to get paid. That's the first point I make. The second point I make is that no matter how, if the attorney is successful and they're entitled to a fee, no matter what or how or why they're successful, the state of Oregon is going to have a say in that fee. They will approve the fee, they will set the fee, they are going to somehow be involved in setting that fee. It's not a private transaction. The state of Oregon is involved in approving that. So that protects you, the injured worker. That is good. It's kind of like you have somebody looking over the whole situation, a different or an added layer of protection, I guess is the best way to describe it. So the state approves the fee. So we got lawyers got to be instrumental, has to have some positive involvement in getting you something you didn't have, and then the state's going to approve the fee. So in the next part of the video, I'm going to go through what different examples of how fees are earned. Okay, so let's start out with the most common way that attorneys earn fees in workers' comp claims and then how they're paid. So most of the cases that I get involved with involve claim denials. And that could be even where a claim is accepted, but certain aspects of the claim are later denied. When a claim is denied, the attorney gets paid if they request a hearing appealing the denial, and go to hearing and win. And so the attorney has to win the hearing and get an opinion in order, that's the written decision a judge makes, that sets aside that denial. If that happens, the judge, the administrative law judge, who hears the case, also decides what attorney fee I am entitled to. And there is a rule the judge follows that sets out several different factors to consider. And based on those several factors, the attorney fee orders the workers' compensation insurer to pay a certain amount of money. And in many cases, actually most cases, if we incur expenses in proving your claim and fighting that denial, the judge will approve those fees, and then we submit a cost bill to the insurance company, and most of the time they just pay it. So we have to win, and if we win, the judge tells the insurance company what kind of fee the attorney is going to get. We call that an assessed fee. Now, sometimes what happens, and I have a case like this in the office now, we're getting close to the hearing, and the insurance company realizes that they probably shouldn't have denied the claim, or there's new evidence that comes to light that makes it clear that the claim should be covered. And they will approach me and say, hey, we're going to accept this claim, and they'll do it by agreement. We call it the stipulation. And then part of that agreement is not only they accept the claim, but they pay an attorney fee and they pay costs. So it is possible that the attorney could earn a fee on a denial even before a hearing, but usually you're going to have to go to hearing. So that's the most common example of an attorney fee. Now, all the other fees that we can earn as attorneys on these cases are dependent on the type of benefit that's being disputed. So what I'll do is go through these kind of quickly. So the other kinds of benefits that could be argued or disputed are time loss, that's wage replacement, permanent partial disability, that's a benefit for your lost earning capacity, your eligibility for vocational services, that's retraining benefits if you're not able to go back to the work that you were doing and you meet other requirements. And then there's medical services. And that's kind of self-explanatory. If there's a dispute about whether a certain kind of medical treatment should be provided or covered. Now, with time loss, that's disability, medical services, and vocational issues, if those are disputed and there's an appeal and your attorney prevails, the state of Oregon is going to order the insurance carrier to pay benefits. If the attorney appeals a notice of closure on the issue of permanent partial disability, usually that's going to involve the amount of the permanent partial disability award. And if the attorney gets you more money for your permanent partial disability, their fee will be a percentage of that increased amount. So if I, as your attorney, get you $100 more in permanent partial disability, then my fee will be a percentage of that increased amount. And I believe it's 25% currently as I make this video. Again, it has to be approved by the state of Oregon. The other example of where an attorney gets a percentage of money going to the injured worker is if the claim resolves by settlement. And that amount is a percentage of the settlement. It's not paid by the insurance company, but it comes out of the money that is paid by the insurance company. So for example, if we settle a case again for $100, I like nice round numbers, then the fee will be 25% of that. It has to be approved by the state. So we actually send the fee agreement to the state, they review it, and they approve it. Now, one thing to keep in mind, and this is something that I have a video that talks about workers' compensation settlements. It goes into great detail if you're interested. But one thing that comes into mind is the state of Oregon is not going to review the settlement to see if it's fair or if it's enough money or if it's a good deal. They're reviewing it to make sure that that settlement agreement complies with the rules set out by the Workers' Comp Board. So be aware of that. If you're negotiating directly with a workers' comp carrier, the Workers' Comp Board is not going to send it back and say, you guys aren't paying enough. This is a more serious injury, or there's more value to this claim than what you're offering. That's not happening. So be aware of that. But there is some oversight. So I just thought I'd throw that in there because I think that's a common misconception. So those are examples of attorney fees that are earned by attorneys who are helping injured workers in the state of Oregon. And I hope this is helpful. And the reason I made this video is I had a client who was concerned about having to put money out to hire me to help her with the claim. Obviously, that's a big deal, especially if you're disabled from an on-the-job injury. I hope this video is helpful. If you have questions, you can contact us. I will leave my contact link below on the YouTube version of the video, and up here somewhere on my website, you can contact us. If we're not able to help you, we will point you in the right direction or find somebody who can. Thank you so much for watching. Take care.